checks were electronic, didn't have a signature on it, but they were from Agra accounts. And because of a set of circumstances, the bank saw these checks and said, why in the world would you be paying down the loan with Agra money? And this had been going on for years and years and years. They just never looked at the deposit items before. So the scheme required that the loan continues to get paid down with the proceeds of the fraud. But on many occasions, and the ones he was convicted for, the defendant had gone that extra step for concealment. And the government submits that at a certain point, you completely eliminate the entire impact of the statute if every act of concealing the source of funds is deemed to be merged with the underlying crime.
What about, let's going back to trying to set the whole deal up. Why wouldn't you have U.S. Attorney's Office have worked through the clerk of court to be sure that there were enough interpreters and so forth?
Well, Your Honor, I guess the answer is the chief judge of the district, first of all, makes the decisions of who within the court community is going to be assigned various tasks. Now, I guess I'd ask Judge Murphy, put yourself in Judge Reade's position. You know, the government comes to you and says, without disclosing ever who the target of the operation is going to be, but you can expect up to 700 criminal arrests. You're not just going to need the clerk of courts, but to be sure the clerk of court was busy preparing the court for doing so. I mean, Judge Reade wasn't doing all the detail work, I'm sure, but you need the clerk of courts, you need probation officers, you need court space. You need attorneys. It's again, 700 criminal arrests. And the other thing, defendant makes this argument that, well, that means that Chief Judge Reade was too aligned with the government. Well, why is the court doing that? The government puts her on notice that there's going to be this action, 700 criminal arrests. Clearly the court can't handle that without a tremendous amount of logistical preparations. And why is that being done? What's going to happen if the court is not ready on May 12, 2008 for up to 700 criminal arrests? Well, who's going to suffer the most? It's not going to be the government. It's going to be the accused. They're not going to get their initial appearance on time. They're not going to have an attorney.
How many meetings were there between prosecution officials and the judge?
And Your Honor, I don't have a number. And I never came to the 12 that defense counsel suggests either. I'd have to go through and I guess see how he calculated that based upon his references. But I think it's at least naive to suggest that based upon what the defendant knew in the fall of 2008 that, okay, well, I'm going to assume that there was just one meeting. Again, if there was one meeting and the defendant was concerned about it, then it was incumbent upon the defendant to say, okay, well, I'm concerned. I want more information on this. What happened is January 30th comes and goes. Defendant files a number of pretrial motions. And again, this was shortly after Chief Judge Reade had reversed the decision of the magistrate judge to detain him. And he was released. And the defendant makes the decision not to file a motion to recuse. And what changed after that? Well, Chief Judge Reade, again, continued to treat the defendant fairly, severed the counts exactly as requested by the defendant, moved the trial based upon pretrial publicity at the request of the defendant, both of those motions over the government's objection, and then presided over a fair trial where the defendant can point to no specific thing that happened that was in any way prejudicial at trial that can in any way be traced to the judge's preparation for those arrests on May 12, 2008. And then there's a sentencing, and the defendant gets a sentence of 27 years, which he understandably feels is too long. And now he's got trying to get another bite of the apple. He's trying to rewrite the history of the case.
Okay, I want to talk about the sentencing, but also Mr. Lewin today talked about Appendix 306, the executive summary, which identified the target as agribusiness or agri-processors. Did Judge Reade have the benefit of that before the arrest?
You're talking about the executive summary that's referenced?
Right.
No, Your Honor. There's no evidence that she did, and I'm not aware of any indication that she ever did. And
What is the executive summary? I don't know what he's referring to. I haven't seen it.
I'm sorry, I haven't either. I don't know. I don't know. But what the court has to do is look at what their evidence in the FOIA document says. He says, well, there's an inference that she knew. Now, and let's think about that for a second as well. There's an inference. And again, the court can look at those documents as well as I can and try to find Mr. Lewin's inference. Okay, I've looked at them all several times, and again, there's nothing in this record to suggest that Chief Judge Reade is misleading anybody when she says that I didn't know the target. And you also have an affidavit from First Assistant Rich Murphy saying I never told, Judge Reade was never told who the target of the operation was. Given that, again, the court has to be very careful to try to make sure that, to look for that link between anything that happened prior to May 12, 2008 in the defendant's trial in South Dakota. Defendant says today, well, I'm not here saying that we need to depose the judge. Well, that's not. Clearly, that is what the defendant's here for. This isn't about additional information. This is about testing those facts that Judge Reade found and which are entitled to deference under a clear abuse of discretion standard by this court. In his original motion at page 19, he said the testimony of the participants, including the trial judge, will be necessary. Now, we looked into it. I don't believe that's ever happened before, and this isn't the case where it ought to happen for the first time, where a defendant who post-judgment rethinks a motion to recuse and files and then wants to challenge the findings of fact that for the most part were already known to him back in the fall of 2008. And for the defendant to say, okay, now we're going to put the trial judge under oath and we're going to test these things. Not based upon the quote-unquote evidence that the defendant comes forward with here today.
What about the sentence, this 27-year sentence? You've heard counsel's arguments about money laundering should be dropped out and all the way up to it's just an unreasonable sentence. It does seem rather high for somebody this age. And this is, quote, a white-collar crime. I don't know what difference that necessarily makes, but this is not somebody that's committing violent crimes or potentially committing violent crimes.
Well, let me address a couple different aspects of it. First of all, it is a bottom of the range as calculated sentence. And even if the court were to say, well, the trial court got the loss wrong, that'd be a two-level difference. It'd still be a within-the-range sentence, which is presumed reasonable on appeal. In addition, the trial judge, as suggested by this court in Vickers, made the alternative ruling that even if I erred in calculating the guidelines, this is the same sentence I would give. That's bolstered by the fact that the trial court actually identified additional grounds, potential grounds for upward departure or upward variance, but decided not to address them or not to go ahead and impose those types of...
Judge Reade always do that, though, in every case.
She does when it's appropriate, Your Honor. And again, going back to Vickers, this court has encouraged the chief judge or all judges to go ahead and make that alternative ruling for efficiency's sake. Now, getting to the actual substance of the sentence.
Talk about upward variances. I recall she made one sentence in her opinion, her sentencing memorandum, that said, I think it was a response to the request of the defendant for downward variance, said, well, really, if I looked at this, I would do an upward variance based on the number of illegal aliens.
Yes.
But she doesn't do that. Is that what you're talking about? That does that drive this at all? The fact, even though that he wasn't convicted of the illegal alien charges?
Well, it's important to remember he was convicted of committing fraud upon the bank by lying about his knowledge of illegal aliens at agri-processors. All you have to do is look at the verdict forms, and the jury was asked, how are the different ways you found that he committed fraud? 4 of them. fake invoices, diversion of income, harboring and then lying about it, not paying your cattle suppliers on time and then lying about it. So that definitely was part of the case, and the jury found beyond a reasonable doubt that it happened. So I do think it's fair for the court to at least factor that in. Now, that being said, it didn't impact the guideline calculation, nor did the Packers Act violations. And the court, even though it mentioned that there's other criminal activity here, and there's other potential obstruction of justice that I could have taken into account, but I'm not going to, because I find that considering 3553A and all the factors, this is an adequate sentence. So I think all of that suggests to this court that, yes, she followed the law, she did exactly what the district court was supposed to do, considered the factors, and arrived at a sentence which the district court felt was no longer than necessary.
Counsel, what's your response to the appellate's counsel's contention that the district court didn't consider all of the 3553A factors and instead declared she didn't care about aspects of the 3553A analysis?
Well, that goes to this motive issue. And she certainly does consider and said that I've considered all the factors and I've considered all of the arguments by the parties. That's in the record. On the motive, there's a line in her sentencing memorandum after discussing the defendant's argument regarding his allegedly altruistic motive for committing his crimes. She says, regardless of his motive, I wouldn't vary downward anyway. But that's after taking a look at really how likely it was that his motive was as claimed by the defendant. And I direct the court's attention to the government's addendum, where there's a line of transcript where a financial analyst talked about all the different things the defendant did, all the different ways he pulled money out of this company, and all the different personal expenses that he paid for, to the tune of over $1 million over the 2 years leading up to the bankruptcy. So I think that what really is happening here is the district judge clearly did consider the defendant's motive. She just wasn't evaluating it. She wasn't weighing it the same as the defendant would like. Well, the law doesn't require that the court give the same weight to a factor that the defendant asks her to give. So, again, Your Honor, I think it's really at best a matter of semantics about this suggestion that, well, she didn't consider motive. She clearly did. She just didn't think that the defendant was very persuasive on this argument that he had these altruistic motives. On the other side, there really is in this case a number of things that really make it extraordinary on the inculpatory side. There's all the different things the defendant did wrong in running the business that were fair game for the court to take into account, either because they were found by the jury or they were part of the record. The harboring and lying about it, the paying the cattle suppliers late, lying about it, the ultimately leading to $5 million of additional loss at the time of the bankruptcy to the bank, to the one bank that was loaning the defendant the money. The invoice scheme, the diversion of income and the not reporting, again, which are two separate parts of the same scheme. There's the fact that the defendant was not only the guy in charge, but he would go into the customer service department to Darlis Henry and tell her, look, I need you to make these invoices and put these bills of lading on them. And then he would go over to the other part, in a different part of the scheme, he'd go into the accounting department and say to April Hamilton, let's see the deposits for today. All right, let's pull out all these checks. And don't tell the bank about them. He didn't say that, but that's the effect of what happened. And then